Williams.
Yes, good morning.
Good morning. Are you the court reporter for all these hearings? Because I'm here for Mr. Potts. Will you be taking all?
Yes, ma'am.
All right, good morning, council and spectators and court reporter. We are
Morning,
ready.
Judge.
We are ready for our motions calendar. Let's get right into it, starting with our position number 1, which is engineered restorations versus TXO Investment Group. I have plaintiff's motion for summary judgment. Do we have both sides here on that?
Robert Friedman on behalf of TXO Investment Group.
And Rich Capriola on behalf of Engineered Restoration.
All right, Mr. Capriola, you can go ahead.
Thank you, Your Honor. Good morning. We represent Engineered Restorations, Inc., which is a contractor, and this is a case for unpaid invoices for work done on behalf of TXO Investment Group, the defendant in this matter. There's a series of written contracts, 4 in all, that are attached to the affidavit for some balcony restoration work. These balconies are on the 40th floor of a condominium building known as 1280 West Condominium Association. The entire floor was owned by TXO, an investment entity that bought the units and was renovating them. And the work was done for TXO and contracted for by TXO, not by the association. Association is not a party to the contracts. The work was performed, but the bills were not paid. After the work was performed, there are email communications that were included in the with the evidence where TXO is promising payment, promising to get you paid in full. I just got to refinance and I'll get you paid in full. No allegations of any of the defenses that have been asserted in this lawsuit, which are without basis and don't deny summary judgment here. So the total amount owed, Your Honor, with attorney's fees is $103,661. And that is a slight change from what was in the pleadings, only because we added to it the attorney's fees incurred for the reply brief, which I'm prepared to state in my place, although I put an affidavit in already that all the attorney's fees incurred were reasonable, necessary, actually incurred, and the attorney's fees totaled $28,682 in total. And I'm happy to have any questions from counsel on those, in addition to $813 in expenses. But getting to the meat of it, Your Honor, we've got the unpaid invoices, which total $51,796. The attorney's fees, as I've already testified and stated, the contract has an attorney's fees provision allowing the prevailing party to, not prevailing party, but my client to recover attorney's fees. So it's not a 13-611 or 9-15-14. This is a contractual attorney's fees provision. And then interest is pursuant to 7416 commercial interest rate of 1.5% on account. So the work, the issues that the defendant has raised, and they've raised 3 discrete issues as to why they claim summary judgment should not be granted here. They make some effort to challenge whether the work was completed. However, the affidavit that was presented by Mr. Thomas, who's the principal of TXO, he does not say that he contends the work was not completed. It's sort of an obscure approach to this. What he says is that the condominium association, which is not a party, informed him that this work had to be done and that he had been fined for the conditions of these balconies. And supposedly the condominium association told him that once this work is done, we'll get rid of these fines. And his position is because the association has not removed the fines, Therefore, the work must not be done. Number one, Your Honor, the statement as to what the association supposedly told TXO is hearsay, and we've gotten our brief that it should be struck. There's no basis for that. I was told by some person at the association that this was the deal. Number two, we got a written contract, and that says nothing about a condition precedent to approval by the association or removal of fines from the account. So, Your Honor, we don't believe there is any basis for that. And if such an agreement even existed, it would be barred by the merger clause in the contract, which says any modifications to the contract have to be in writing, or they're unenforceable. So for multiple reasons, that effort at a defense fails. The work was completed, and we've got an affidavit in the record that says the work was completed and no evidence to the contrary. The defendant even goes so far as to admitting that nothing in the contract requires the association's approval of the work. So really nothing there to argue about. The second defense is equally, we believe, spurious, which is that monies were put into an escrow account, and the law firm who was holding the escrow account supposedly stole the money. And therefore, somehow that should be an offset against what my client should recover. So let's break that down. Before my client ever entered into a contract with TXO, TXO sold one of these units to an individual. Her name happens to be Sharon Davies. And part of that closing, Ms. Davies and TXO agreed that about $24,000 was going to be put into escrow and held by the closing lawyer. And that money was to either be paid to Ms. Davies or to TXO, but not to my client. My client is not a party to that agreement, never had any say in it, was not, even a contracting party with TXO at the time. And whatever happened with that money, if it was stolen or not, is certainly not my client's responsibility. My client then entered into a contract with TXO that says, you pay us when we finish the work. It doesn't say anything about an escrow payment coming to them. So this effort to push this potential theft of escrow funds from some law firm onto my client's shoulders is not properly placed. And then the last thing, Your Honor, is there's a claim to an offset for some what's called scuppers. It's a part of a drainage system on a balcony. And what the defendant is claiming is that an agreement was reached about a year before the contract's at issue with my client that there would be a $1,400 per scupper reduction in the price because the association was supposed to pay for the scuppers. That's 1 year before these contracts. A year later, we enter into contracts. The contracts call for the scupper work to be done. Does not say that the association is paying for it. It says TXO is paying for it. And that was the contract. The work was done. TXO isn't paying for it. And now it's claiming that there was some verbal agreement of some sort that predates the contracts that should be enforced by this court as an offset. So, Your Honor, again, barred by the merger.
I have a question for you about the scuppers.
Yes, sir.
So looking at the invoices, it looks like that there was some kind of credit applied. Can you inform me as to why there was some at least partial credit applied on the scuppers? Because that wasn't part of the contract either.
Your Honor, that was an accommodation of some sort, and I don't know the details of it. There's no evidence in the record that we have about that as to why that was. There was a credit given. They didn't take the deposition of my clients, so we have the record that we have in front of us. And so there was an accommodation of some level. I think it's $250 per scupper was given as an accommodation there. So, I can't go outside the record, and that's what we have here. But, the statement that it should have been $1,400 per scupper, there's no basis for any discount never mind a $1,400 discount. I hope that answers your question, Your Honor.
All right.
Okay. And with that, Your Honor, I'll conclude and save my remarks for rebuttal.
All right.
Good
Mr.
morning.
Friedman, you've got an uphill battle here.
Sure.
Contract seems to be pretty clear. And I understand all of sort of the fairness arguments, and I understand the position that your client is in, dealing with maybe a cantankerous homeowners association and dealing with a perhaps unethical attorney. But I'm having a hard time figuring why the plaintiff in this case should bear that burden, and why it's not your client's burden to pursue claims against the homeowners association or against the attorney.
Sure. And I'll give you some background, and I'll try and help clarify as much as I can. And what I will say, just as a preface to my argument, in the sense that, like, what is my client overall attempting to obtain here? In the sense that at the end of the day, my client's not a scofflaw. He wants to pay for work that was done. This is not an attempt by my client to say, you know what, he doesn't owe ERA any money. What my client is simply trying to do is protect himself. All he wants at the end of the day is a sworn statement from the association that says that the work was done properly and that they have no issue with it. And at that point in time, my client can then conclude that the work was completed, and then he'll pay the principal, if that's provided, pay the principal, but he doesn't think he owes interest and attorney's fees because that was never provided before. That's the actual remedy that my client is after, in addition to the discounts. But let me go just a little bit of background here and explain what happened. So the contract is for work on balconies, and it's true that my client owns the 40th floor. But what my client doesn't own is the balconies. I'm not sure if Your Honor is familiar with how condo associations work, but the four walls of my client's unit, those are his property. He's responsible for it, and he's allowed to do with what he wants within the four walls of his units. Outside the four walls of his units are common elements. Common elements come in two forms. There are general common elements and there are limited common elements. The balconies are limited common elements. Because they're a limited common element, they're not entirely owned by my client, and they're not entirely owned by the association. There's a shared ownership of these balconies and shared responsibility for what needs to be done in terms of repairs. So how did we end up in this situation? So when my client bought the 40th floor, he bought it as an investment property, and the entire floor was demolished prior to him coming in. He bought the 40th floor and basically submitted a proposal to subdivide the 40th floor into units in order to renovate them and then sell them. The association approved that proposal, and part of that proposal involved work on the balconies. At some point in time during the actual construction, an issue arose where a floor, this is the penthouse, so the floor below, like the 40th floor is the penthouse, the 39th floor before. There were complaints by people on the 39th floor that there was a leak. Something was leaking from allegedly the balconies. So the association approached Drake Thompson on behalf of TXO, that's my client, and they told him that you need to, do something to fix it. My client doesn't have any say over what or how the balconies are repaired or how they're determined. The only thing my client can do is submit a proposal. That proposal has to be approved by the board because it's a limited common element. And then they determine a scope of work. And then that scope of work is the only thing that can be done. So my client threw up his hands and said, look, I don't know what you want me to do here. I obviously can't control any work on the balconies. And they're saying, well, there's a leak. It's a limited common element. Here's what we want you to do. We want you to hire Engineered Restorations, and Engineered Restorations Incorporated, ERI. That was their preferred contractor at the time. They told them, hey, this is what we want. We want you to hire these people. We want you to fix these balconies. And that's, and if you don't, like, we're going to start fining you. And my client basically didn't want to do that because, he doesn't have any relationship with ERI and he doesn't have any control. He wanted to use his own contractors, but then they put assessments on his account for the limited common element. And they told him that, like, unless and until you do exactly what we say, which is hire Engineered Restorations Incorporated and do the scope of work that they determined, not my client, these fees are never coming off your account. So my client's in a bind. He has no choice. So he signs these contracts and he agrees to have the work done on the balconies. So fast forward, and the work is allegedly completed and they submit bills to my client. But the HOA still hasn't removed any of these fines, any of these assessments. They haven't provided any notice of completion. They haven't provided anything that essentially gives my client cover. And that's what I said. That's all my client wants. All my client wants to know is if he pays Engineered Restorations Incorporated, that he's done, that he doesn't owe anything more on those limited common elements on the balconies. And that never came. And we, during this litigation for, I don't know, close to however long this has been going on, have requested that from ERI. Please just give us a statement from the association that says the work was done to the satisfaction of the association. Because at the end of the day, my client can't accept the work. Like, the primary argument here on whether or not the work was completed is that he's saying, well, my client is the arbiter of that. And therefore, there's no evidence that my client is saying what was done wrong. But the problem with that argument is that my client's not allowed to say what was done wrong. My client wasn't even allowed to determine the scope of work. The only entity that can determine whether or not the work by ERI was done sufficiently and according to the contract in a workmanlike manner is the association. And that's just a matter of law under the Condo Act. Like, there's nothing my client can do. So I don't think that's unreasonable. I think that's a perfectly reasonable thing to ask for, and it shouldn't be hard, right? Like, this should be easy. If ERI did the work as they requested, all they need to do is go to the association and say, hey, pick up the phone and call Drake and tell him that the work was done properly. Send him an email. It doesn't even need to be a sworn statement. Do anything that says that, look, you know what? These fines are for something else. You're being fined for some other reason. The work by ERI was done perfectly. We have no issue with that. That's all we want on that issue. On the issue of whether or not the work was completed, all we want is a statement from the association, from the board of directors, via something that my client can hang his hat on and say, yes, this was done. And then he will say, okay, you're right. At least with respect to the issue of whether the contract was completed, the contract was completed. As of right now, as we sit here today on the record, there's nothing in the record that says that the contract work was completed, because legally, the only person that can determine whether the contract work was completed is the association. It would have been beyond easy for ERI to simply respond to, in a reply brief and simply put forward an affidavit from anyone from the association and say, look, this is nonsense. You know what? All this work was completed and it was done fine and we have no issue. You know what's missing from the record? Any affidavit from the association that says that that took place. So you've got an allegation from my client that says, hey, I don't think this work was done. And here's why I don't think it was done. I don't think it was done because the only person that can determine whether or not the work was completed is the association. And the association has never provided me anything that says that the work was done to their satisfaction. Now, his argument is that's hearsay, but it's not hearsay. It's a missing element. Like, it's not as if I am proffering, the statement of a declarant that's not present to offer a defense to the contract. What I am saying is that there is something missing from the record that shows that the contract was completed. That's not hearsay. That's a missing element of proof. The missing element of proof being that the contract work was completed. And my client's allegation as a defense, which is not disproved by anything in the record, is that as a matter of law and as a matter of record, the only person that can determine contract completion is in fact the association, because he doesn't own the property that the work was done on. And that's not in the record. Do you have any questions about the contract completion element of my client's defense?
My question is a little bit broader than that and more overarching. I hear in your papers and I hear in your argument everything about what the homeowners or the condominium association did or what the condominium association hasn't done and how that's affected your claim. Why aren't they a party to this lawsuit? Why isn't there a cross claim? If there's some allegation that they're holding funds based on what ERI did or didn't do, why aren't they a party to this lawsuit? Why isn't there any testimony from them? Why isn't there any discovery as to them so that I'm not hearing what your client understood to be the case from them, but seeing actual documents or testimony as to what actually was said by whom.
The problem is that the truth of the world is that's being handled in separate litigation. So my client got sued. So in reality is that my client, there's a separate issue involving the association and the 40th floor was a mess. So this is one of about 5 different litigation problems that arose out of the 40th floor. My client ended up in litigation with the association, and the association filed a counterclaim for all of the assessments, including potentially the assessments for the balcony, in a separate lawsuit. So I don't believe I could file a cross claim. I think at best, maybe I could have tried to merge these lawsuits together, but that would have made things even more complicated. The other problem is that it's not as if I haven't over the last year been trying to get the association to do exactly that. Like I have been in discussions with the association for the last 12 months, trying to figure out exactly what all the assessments for, to understand their ledger, to figure out, like, to break these things out piece by piece and to figure out, hey, what's actually going on here? And like I said, that's the subject of independent litigation. But to your point, in the sense of like, okay, so what can I provide to the court to basically show that either the work wasn't done? I can't do that, in the sense that, like I said, the issue here to me is it's a matter of proof, not a matter of defense. I am saying that in order to, if you come to the court and you say, I have a contract, it was completed, I did the work, I deserve to be paid. An element of your proof is exactly that the work was done and it was done in a workmanlike manner. But we don't have that. Like we don't, and the reason is because he's saying that, like, well, if it, like, imagine this, imagine ERI didn't do any work. Imagine the scenario where ERI just contracted with my client, said they did the balcony work, but they never literally stepped foot on the balcony. Again, my client doesn't have the, like, from my client's perspective, there was nothing wrong with the balconies to begin with. Like, does that kind of help clarify this, in the sense that my client is accused of essentially saying you're leaking water onto a unit below? My client disputes that, says, I don't think there's anything wrong, but I'll have my contractors take a look at it. The association says, no, you are definitely at fault here. And you know what we need to do? We need to put like waterproof lining, do all this other stuff. And, you know, that's what ERI is going to do. My client doesn't.
So essentially what it boils down to is that your assertion is that ERI hasn't sufficiently proven that they've completed the work in a workmanlike manner.
That's exactly right. And what I'm saying is the burden to prove that they've done it in a workmanlike manner is low. I'm not suggesting that they have to do something onerous. All I'm saying is it's not my job to essentially drag the association here. I'm saying that if the association requested the work for a limited common element that the association owns, even if my client contracted with it, the only arbiter of whether or not the work was done is the association. All we're asking for is something from the association showing that the work was done. If that happens, then my client, because it cuts both ways, Your Honor. Like, so my client can't determine whether or not the work was done properly or improperly. So if we received something from the association that says, to the association's knowledge, the work was done properly, my client's hands would be tied, because I wouldn't be able to dispute that here, because again, the arbiter is the association. So if they had something from the association that says that their work was done in a workmanlike manner, the issue of contract completion would be a non-issue. But that's not here, and it's not in the record, and it remains a disputed issue of fact that we should be able to solve.
But if someone from the company says we've completed the work satisfactorily according to the contract, here's our invoice, and there's proof of that in the record, doesn't the burden then shift to your client to show that it wasn't in fact done in a workmanlike manner?
In a normal contract case, I would say yes, but there's a complication here. Like, this isn't normal. Like, this is a situation where someone was essentially forced to contract for a property that they don't own. Like,
but the problem is, we've got a written contract. All I can do as the court is enforce the contract as written. And there's
okay.
not even a hint that someone else is a party to this contract, or that TXO didn't sign the contract and agree to all the provisions. There's nothing in there in the record of that.
There's nothing in the record that says that my client didn't sign the contract. I am in agreement that my client signed the contract. but there's nothing in the contract that says one way or the other how we determine contract completion. And the fact that an invoice was sent is certainly not going to be enough in any case to show that the contract work was done in a workmanlike manner, especially if there's a dispute. Like an invoice by itself isn't going to say, you know what, I did a bunch of construction on balconies. The issue here is like you said, okay, well, in a normal contract situation where you own the property that the work is being done on, then you have the ability to basically say this wasn't done to my satisfaction. But you've got a unique scenario here. And I get what you're saying in the sense that this is unique, but it is markedly unfair for my client to be forced to essentially pay for an invoice for work that was done and pay attorney's fees and pay interest when all he's asking for is just basically a notice from the party that owns the property to basically say that the work was done to their satisfaction. That seems like a low bar.
It seems like a low bar for the condominium association, but according to the contract that I have to enforce, it's not ERI's responsibility.
But it is, you would agree that it is ERI's responsibility to finish the contract work in a workmanlike manner. And you would agree that submitting an invoice by itself is certainly not evidence that it was done in a workmanlike manner. And you are in agreement that as a matter of law, under the Condo Act, that the limited common element of the balcony is not owned by my client as a condominium owner.
I can't go that far.
I will testify to you.
I don't have that in front of me.
I understand, but I will represent to the court, and it can be checked later if there's an issue as to it, that this is in fact a limited common element. And as a result, my client doesn't own it and does not have the ability to determine scope of work, workmanlike manner, any of those things. What the contract essentially, in my view, boils down to is this, is that, and you know, like I said, this cuts both ways and it cuts in ERI's favor. Just like my client can't determine whether or not the work was completed, my client has no ability to dispute the work that wasn't completed if the association says it was. So let's say you had a scenario where the association submitted any kind of proof in this case and said, you know what, the work was done in a workmanlike manner and we have no issue with the work done by ERI. And my client disputed that. And he disputed and said, no, I don't think so. I think the work was done poorly. The issue would side with ERI because the arbiter is the association. My client doesn't have any, this is my point in the sense that, like, yes, the contract makes my client responsible for the work if it is done correctly and workmanlike manner and completed, but the completion of the work has to be determined by the owner of the property. And that to me seems fair. My client is not saying I don't owe the money. My client is not saying I'm not responsible for paying for the work. My client is saying one thing on the issue of completion and one thing only. I just want to know that the work was done. And if it was done, then I owe you the money that I fairly contracted for. That's fair. On the other two issues, the specific issue about the amounts of work. So I want to talk first about the escrow agreement. So what happened with the escrow agreement was that ERI, like an agent of ERI, specifically his name is Scott Gray, basically told my client that the only way that the work would start is if he put this money into escrow. And I'm going to try and share my screen and show you the deposition of Drake Thompson to show you his testimony. Oh, let's see.
I have to let you.
Okay.
Hold on. All right, go ahead.
Sure, let's see if I can do this. All right. Can you see the deposition transcript, Your Honor?
Yes.
All right, so we're on page 58 of Drake Thompson's deposition. And I'm going to start on line 3, where he's talking about the fact that he prepaid for this work. All right, question. Okay, that's all. Now, you said that you prepaid. Going back to the answer you gave when you laid out a few things for me, you said that you prepaid the amount above and beyond the work. Verbally, please answer with that. Please with that answer. Oh, sorry, yes. What do you mean prepaid above and beyond the amount for the work? Answer, ERI would not allow me to, would not proceed with the work unless because I no longer own the unit, because this was a sale, you know, at the time the work was going to start, so that the only way they would do that is if the buyer signed the contract and the money was prepaid from me into escrow. That's what I did, you know, upon direction. Question, who directed you to do that? as you are testifying, sir? Answer, I guess they were the buyer's representatives, brokers, Scott Gray, and I guess my representative at the time, which was Amanda Straussen, which was his real estate agent. So Scott Gray is an agent of ERI. And Scott Gray submitted an affidavit in support of their motion for summary judgment on behalf of ERI. And what's missing from Scott's Gray affidavit is any dispute as to that testimony. This is an agent admission that's undisputed. So in the record, as we sit right now, it is undisputed that an agent of ERI, as a precondition to the contract, made my client put $24,000 into escrow with Dickerson Law Group. Now, through the fault of no one, other than Dickinson Law Group, which has been dissolved and they've been disbarred, they stole that money along with millions of dollars of other people that were clients of Dickinson Law Group. So the issue here is again, it's a question of fundamental fairness. So my client has no choice but to do this work because the association is forcing him to. He signs the contracts and we're in agreement that he owes the money if the work was completed. But he paid $24,728 into an escrow with Dickerson Law Group at the request and demand of Scott Gray. I will not do the work unless you do this by putting money into escrow. He testified to that under oath and deposition. Scott Gray submitted an affidavit in support of summary judgment, didn't dispute the testimony. It's an admitted fact at this point, and it's an agent admission. So we know, as we sit here today on the record, that the contract can't happen unless ERI's condition of escrow is met. And they picked the escrow agent. Like, they're the ones that picked Dickerson Law Group. Yeah, I get it. They didn't steal the money, but the money got stolen and my client didn't want to put money into escrow. Is it reasonable and fair that he just bears the entire cost of that? Like, I just think there ought to be some issue that a jury ought to be able to resolve, that it's not an issue of law here, that my client that just is just eating $24,728 that was only prepaid for part of the contract because Scott Gray demanded it on behalf of ERI. Do you have any questions about the escrow argument, Your Honor?
Nope, no additional question.
All right, and then the last issue is the issue with these scuppers. So we talked a little bit about limited common elements and common elements. So these scuppers are things on the areas of the roof near the balcony. So if the limited common element of the balcony, like I said, it's a limited common element. There's shared ownership, but reality is you can't do anything unless the association says so. Scuppers are a completely different category. Scuppers are a general common element. My client has literally no ownership interest in the scuppers. The scuppers are literally things attached to the building. I'm not a construction guy. I don't know exactly what they do, but it's undisputed that the scuppers are not anything other than a general common element. So you rightly asked, like, why on the contract did it show a credit for the scuppers? The reason why there was a credit for the scuppers is exactly that, is because they're a general common element versus a limited common element. And as a result of that, the association agreed that there should be a reduction. So here's where things get really interesting. So, and I'm not trying to accuse counsel of doing anything improper, but I will say that he's at least a little bit talking out of both sides of his mouth. So you wanted to know, where did that actual reduction come from? And it was in my client's deposition where he explained exactly where that came from. It came from Joseph David. So Joseph David, who was the building engineer of 1280 West, the condominium at issue, who owns the scuppers, negotiated independently with ERI for a reduction in the contract price without my client's knowledge or consent. And then he just received notice from ERI that said, hey, congratulations, we're giving you a reduction on the scupper price. We negotiated with the association and came to this reduction price that they think is fair. And this is how much we're going to reduce it by. It's ridiculous. So on the one hand, they're saying that the association is not a party to the contract and that they have no say in anything that goes on, and that somehow my client is supposed to determine whether or not work on a common element was done to their satisfaction. And at the same time, they're going over to the building engineer, negotiating independently with the association without my client, and negotiating contract terms after the contract is signed to arrive at an amount that they determine to be fair for a reduction for the general common element. Like, this is a disputed issue of fact. We know for an issue that there was an amount in the contracts that the scuppers were paid for. Then we know that there was some agreement that was reached with 1280 West that resulted in a reduction in that price. My client has testified under oath that he was not a part of that agreement and that his understanding was with ERI that it was supposed to be $1,400 per scupper. Instead, he only got $250. The $250 was negotiated by the association. This is like, again, this is another situation of fundamental fairness. Either the contract is with my client or it's with the association or it's with both, But it's not reasonable for ERI to be negotiating with the association for reductions without my client consent. If there should be a reduction, my client's the one as the contracting party that should be able to have a say in like what is reasonable and fair. And my client's understanding is that it was a different amount, and that's a disputed issue of fact. You have any questions about this scupper issue, Your Honor?
No, sir.
Is there anything else I can add to help clarify any of this issue? I recognize this is a unique situation, and like I said, all my client wants is fundamental fairness here. He wants to pay for the work. He doesn't want to pay for attorney's fees and interest. He just wants assurances that the work was done to his completion, and he wants some credit for the fact that nearly $25,000 was stolen from him simply because ERI required that this be put into escrow. Again, not trying to not pay our bills. We're just trying to get something that's fair, Your Honor.
All right.
Can I briefly respond, Your Honor?
A couple of specific questions
Yes, sir.
for you from the outset, and then I'll let you finish with whatever else you want me to know. So what is the proof in the record that the work was completed in a workmanlike fashion?
Your Honor, we have the affidavit of Mr. Gray, where he specifically says, let me just get it in front of. It's the affidavit of Scott Gray, paragraph 12. ERI timely completed all work in accordance with the terms of the contract in a good and workmanlike manner. That's all we need, Your Honor. Then the burden is on the defendant. As you noted, they could have gone and got a contractor to look at it, look at the scope, said the work wasn't done right. This whole premise that somehow the association was the arbiter of work is not in the contract, and there's no basis other than hearsay as to what he was allegedly told to support even the basis that we get into that discussion. So, Your Honor, if we have it, and you're right that the burden then shifts to the defendant.
All right, second question. Assume that, I'm just assuming, and we can go a little bit deeper on this, but assuming that Scott Gray did say to TXO, you need to put this money into escrow. Why doesn't that mean, why shouldn't that then be credited towards the amount that ERI says is owed?
Your Honor, you got to look at the escrow agreement, which is attached. It's an exhibit. Escrow agreement is between TXO and the purchaser. ERI is not a party. Next thing you look at is it's the closing lawyer who did the transaction for the sale of the unit, right? So it's not like it was ERI's attorney that was holding the money. It's the closing lawyer. That's commonly what happens, right? ERI is not even in the picture at this point. Third thing, Your Honor, the escrow agreement says when the work is complete, the money goes to TXO, not to ERI. Or if the work isn't completed, it goes to the buyer. So it never flowed to ERI. We are not a party to it. We were never supposed to receive it. It wasn't sitting there for us. We didn't even, we couldn't enforce it if we wanted to. And significantly, this, as counsel just said, all took place before TXO entered its first contract with ERI. There is nothing in the contract that says anything about paid out of escrow. And there's a merger provision, and I know Your Honor is fully familiar with those. All prior discussions and agreements of any sort are void. It's only what's in this contract. So even if there were an agreement that this money would be in escrow, it would have merged into and been bound by this contract that just says, you pay us when we're done with the work. You, TXO, no one else. And then finally, Your Honor, if there's theft, there's no law that's been presented that somehow my client's responsible for the theft of a licensed attorney in any respect. They could chase down that lawyer. It was supposed to be TXO's money, I believe, at this point.
All right. I know you're probably anxious, Mr. Capriola, to continue and give me a closing argument, but you don't.
Only if I need it.
You don't need to do
All
that. You're entitled to summary judgment.
Thank you, Your Honor.
And you're entitled to summary judgment as to the amounts requested as modified today. Now, as to the attorney's fees, I think I need to at least give defense counsel an opportunity to inquire or to examine as to the nature and sufficiency of those fees. If Mr. Friedman, you're prepared to do that today, we can do that today. If not, I'm happy to put this over to another hearing on fees as to attorney's fees only. But summary judgment is granted. There will be attorney's fees awarded as well as the amounts requested here today. Just the question is whether, Mr. Friedman, you want an opportunity now or at a future date to question or examine Mr. Capriola as to the amounts and sufficiency of that work.
No, I think what I really want to do is ask my client that, in the sense that I'm not prepared to discuss the attorney's fees issue today, and I want to just get a up or a down for him, and then I'll be able to communicate that to the court.
All right. So we'll have a hearing as to we'll set a hearing as to the fee issue only. But summary judgment is granted.
If I may ask for just one clarification, can we submit an order as to summary judgment and then leave open the fees? And as I heard Mr. Friedman say, he'll let us know if he wants that hearing or not.
Yes,
Mr.
so
Friedman, would you be able to let us know that in the next 2 days, maybe, so I can then decide whether to submit the order as is with the blank for fees or not?
Yeah, I'm just going to call my client and find out. So I should be able to let you know in 2 days.
Okay.
all right, so go ahead, Mr. Capriola, and prepare a final order and judgment. Run it by Mr. Friedman. And Mr. Friedman, if you can agree as to form but not substance, then we'll go ahead and get something entered and schedule another hearing if we have to have one.
Okay, thank you, Your Honor.
Thank you, Your Honor.
All right, thank you both. Y'all are excused.
Thank you.
All right, let's go to, I think we have an extra court reporter. Is that right, Ms. Williams?
Yes, sir. Miss Lita Seaborn.
Hi, I was just waiting around to see if I could be dismissed since you already have a reporter there.
Yes, you can be excused. I appreciate the extra backup coverage, but we'll let you go.
Thank you. I was here for Mr. Potts.
All right.
All right, thank you.
And Mr. Potts, that's given court reporter shortages that we faced, not a bad idea to have somebody around for backup. We are covered today. Thank you. All right, so let's go to my position 3, which is Saunier versus Richard Young. And I have a motion to dismiss.
Yes, Your Honor, this is Heather McGrady on behalf of Dr. Mi Young. And we did file the motion, sir.
All right, I'm ready to hear.
Thank you, sir. Let me grab a couple of notes real quick. Just to give you a little bit of background, Judge Richardson, there are 2 different Saunier cases that are pending before you. And the motion to dismiss is in what I call Saunier 2. But let me give you some background so that you can have an understanding of what we're dealing with here. Dr. Mi Young is a cardiothoracic surgeon and performed a coronary artery bypass grafting procedure on Mr. Saunier back on November the 19th of 2018. He ended up passing away on November the 26th of 2018. Plaintiff filed a lawsuit, which I'm calling Saunier 1, against a multitude of WellStar defendants whom we also represent. There are 17 different defendants named in the Sonyer case. All of them, other than the John Doe defendants and Dr. Kloss, all of them are WellStar employees. There are, I believe, 5 nurses that have been named, 4 or 5 mid-levels, and 4 physicians named in that case. All of it arises out of plaintiff's allegation that Mr. Sonyer passed away due to heparin-induced thrombocytopenia, also known as HIT, and that the defendants discontinued heparin and failed to initiate a different antithrombotic to prevent his death. That's the claim. Sonyer 1 was filed on September the 11th of 2020. Based upon the statute of limitations and adding in the tolling provisions from the COVID-19 pandemic, the statute of limitations expired on March the 29th of 2021. I think sensing the fact that attempting to move to add Dr. Myung, who's the cardiothoracic surgeon, to the case, knowing that we would object to it being untimely, instead of filing a motion to amend the complaint, plaintiff instead filed an entirely new lawsuit, which I'm calling Sonyer 2, that is basically a cut and paste of his complaint in Sonyer 1. And it is against Dr. Myung, the cardiothoracic surgeon, for arising out of the death of Mr. Sonyer, alleging the exact same thing. That lawsuit was filed on August the 20th of this year. We filed our motion to dismiss on September 23rd on grounds that it was barred by the statute of limitations. Instead of responding to our motion, plaintiff filed a amended complaint in Sonyer 2 on October the 19th of this year. And again, it is a predominantly 99% a cut and paste of the original motion, but instead there are a few new paragraphs that have been added that are on paragraphs 80 through, I believe, 91, that allege that the statute of limitations should be tolled due to Dr. Myung's fraudulent concealment of his involvement in the case. Plaintiff specifically alleges that she had no way of knowing Dr. Myung's involvement in the cause of action prior to the deposition of his physician assistant, Delene Huff, who is a co-defendant in the Sonyer 1 matter. That deposition took place on June 29th of 2021. And then he also, Ms. Sonyer also alleges in paragraph 82.1 that none of the medical records or other documents provided by defendants to plaintiffs contain any mention of Dr. Myung's involvement after surgery in either discontinuing the heparin or starting or failing to start a non-heparin anticoagulant. And just I recognize that this probably sua sponte would turn this into a motion for summary judgment, which I know the court has the ability to do, because you do have to go outside of the pleadings at this point and point to a couple of things that make these representations, frankly, just blatantly wrong. They're just not correct because the plaintiff did know of Dr. Myung's involvement in the care and treatment, as she has testified to. Her deposition was taken on May 11th of this year. And in that deposition, she acknowledged speaking to Dr. Myung on November 25th of 2018, which was the day before her husband died, and that Dr. Myung was the first person to mention the word HIT to her, heparin-induced thrombocytopenia. That's the first time she had ever heard of it. She also testified to remembering that Dr. Myung said he wanted to run a HIT panel. That's on page 74 of her deposition. And on page 75, she said that Dr. Myung said that he really didn't think it was HIT, but he wanted to run one just to be sure. And then she also admitted and I asked her on page 75 into page 76, did he also tell you that they were going to stop the heparin? Her answer was yes. So Ms. Sonier knew from the moment the decision was made to run a HIT panel and stop heparin of Dr. Myung's involvement in the case. He is the cardiothoracic surgeon who performed the CABG procedure on her in the first place. And the PA that was following her was from his team, Delene Huff. And also on that very day, on November 25th, she acknowledged knowing that he was going to discontinue the heparin and run a HIT panel. Additionally, she has had the medical records from Wellstar Kennestone Hospital since May the 20th of 2019. And within Delene Huff's note from November the 25th of 2018, she notes the fact that a HIT panel is going to be run and that heparin is on hold. She also says in her note that the wife is very upset with the patient's care. She wants her husband to go home today. Dr. Myung talked to the patient and wife in private. In parentheses, wife asked to talk to him alone, end parentheses. Dr. Myung told her that to be thorough, we needed to check a HIT and check platelets in the AM.
All right,
So,
Ms. McCarty, I'm going to stop you there. I want to turn to Mr. Potts here. Now, clearly, we're now, and as you acknowledge, Ms. McCarty, we're at documents outside and testimony that are outside the pleadings. So not apt to a motion for dismiss unless it's converted into a motion for summary judgment. And perhaps with a little bit more time, we could have done that. Mr. Potts, I want to speak practically.
Yes, sir.
You respond to the motion. You filed amended complaint. Based on just what I'm hearing from one side, it sounds like, well, let me just ask it positively.
Sure.
What's your basis for alleging fraud?
Well, it's actually concealment, and our basis for it is what, I don't know whether you got our pleading that we filed this morning. We got their pleading late yesterday. We don't have any issue with the heart surgery. We don't have any issue with prescribing heparin, an anticoagulant. We don't have any issue with stopping heparin once you see signs and symptoms of HIT, heparin-induced thrombocytopenia. What's going on is the drug is causing the blood to clot. If you stop heparin and don't start a non-heparin anticoagulant, that blood will continue to clot until that patient dies. That's black letter medicine. And what's in the medical record is that the best case for opposing counsel to this conversation, and if I can share the screen, I'd like to share some of that with the court. At 10 that morning, these conversations took place, and best case under that deposition, Dr. Myung says something akin to, well, they're going to run a HIT panel. They're going to stop heparin. I don't think it's heparin, but if it is, that's what's going to happen. Stopping heparin when you suspect a patient suffering from HIT is the thing to do. Not starting a non-heparin anticoagulant is what killed this man. According to that medical record, that happened at 5:31, 7.5 hours later after this conversation. According to that medical record, which is a medical legal document, which federal law requires to be accurate, which federal law requires these orders to be included in that medical record, they're not there. It was Dr. Camphor, the hospitalist, in consult with a hematologist. That's another thing that in the deposition, Dr. Myung told the surviving spouse that they're going to consult. She testified oncologist. I believe she meant a hematologist. All that happened at 5:30 that evening. There's not one order. There is no record of that telephone call by either Dr. Myung or the PA Huff until after the period of limitations runs. And we deposed her in June of this year, and she testifies And I believe this is a quote that Dr. Mayung ordered, again, no record of that, ordered her to DC the heparin and ordered her not to start a non-heparin anticoagulant. The plaintiff had no way of knowing that. That's not in the medical record. And it's just, dead wrong. And for her to lie in wait like that, and for him not to disclose that, I can point the court to some cases that we cited. These are Georgia Supreme Court cases, and they're at page 5 of the briefs we submitted this morning. Whereas here, this physician, persons sustained toward another a relation of trust and confidence. Their silence when they ought to speak is as much a fraud in law as an actual affirmative false representation. That's Morris v. Johnstone. The cites, that's at 172 Georgia 598, Brown v. Brown 209 Georgia 620, Lawson v. Garnwell 165 Georgia Pills 425. We have an issue with Dr. Mayung to the extent that it happened. This is a day before this man died. If he told that PA, to start a non-heparin anticoagulant, that would have made a difference. If that PA had heard from him that, no, you can't dare stop that heparin without also starting a non-heparin anticoagulant, this guy would still be alive. And the record doesn't reflect any of that, nor does her deposition reflect that he said anything remotely akin to any of that. So this is, we don't sue people that we don't feel are responsible. According to that medical record, he did nothing wrong. According to what she testified to after the period of limitations had run, he absolutely did something wrong. What he did was tell a PA not to start a non-heparin anticoagulant, again, black letter medicine, which led to this man's death. This is, she used the word involvement earlier. That was what opposing counsel shared with the court, that we didn't know of his involvement. Of course we knew of his involvement. Of course we knew of his surgery. We have no issue with the surgery. We have no issue with the heparin. We have no issue stopping the heparin. What we have an issue with is not starting a non-heparin anticoagulant, which is what the PA testified he ordered. And that's nowhere in that record, nowhere in that deposition. And that's why we've added him to this lawsuit, Your Honor. I'm happy to answer any questions you may have of me. And I'm happy to.
Here's what we're going to do.
Yes, sir.
Because I don't think we're in the right posture
Yes, sir.
to decide this.
Very
So I'm going to invite Ms. McGrady to file a motion for summary judgment on and focus the briefing on the issue of whether there's a sufficient allegation.
I'd like to share with the court, just in passing, that this is Johnson v. Garnwell and Ligon versus Levin. These are also cited in our brief. The question of the existence of such fraud or control and the related question of the patient's exercise of diligence in discovering the injury and the fraudulent concealment are, quote, ordinarily for jury determination. I'd like to go ahead and make the court aware of that as well.
I just had a jury trial, which we
Yes,
didn't
sir.
finish just a couple of weeks ago on the issue of whether there was fraud or not. So
Sure.
there may very well be a jury question on that. There may not be. But
Sure.
I want to get a full record in the proper posture before we decide that issue.
Very well.
Yes, Your Honor. I have not received a copy of the brief that Mr. Potts has referenced a couple of times now that he filed this morning. I have not seen it. No courtesy copy has been sent to me yet. So, Mr. Potts, if you could please get that to me, I'd appreciate it. Is there
Yes,
any
ma'am.
particular time frame, Judge Richardson, that you would like us to get this motion to you?
If you get it to us within the next 15 business days, so we give you another 3 weeks to pull it together, that would be great. But I'm not imposing a strict deadline, but it seems like it's in everybody's interest to get some certainty on this issue as quickly as we can.
I agree, Your Honor, and we will endeavor to have it to you before Christmas.
Oh, that's
I think
right.
that's
I'm,
15.
when I say 15
That's
business days, I'm putting you right at the Christmas holiday. Let's go to January 15.
Okay. Thank you, Your Honor. I appreciate that. We will get you the motion filed by January the 15th.
All right. Very good.
Thank
And
you, sir.
Ms. McGratty, when he said he filed his response, I hadn't seen it, but it is in the electronic file. So it has been electronically filed.
Thank you. I wasn't suggesting that it hadn't been, Your Honor. I was just making it clear that I haven't seen it. So thank you.
Ms. McGratty, I also emailed you a courtesy copy this morning and.
Oh.
Yeah,
Thank you. I haven't seen it, Jim. I haven't seen it, but I'll look for it. Thank you. All right. May we be excused, sir?
Yes, you may be excused. Thank you both.
Thank you very much. Have a happy holiday.
All right. I'm actually going to skip Dewana Lane versus M Entertainment for now. We'll come back to that last. I'd like to go to Ms. Kraft versus AMC.
Good morning, Your Honor. Pete Brogdon on behalf of the plaintiff, Ms. Kraft.
Good morning, Your Honor. Lauren Kaminsky on behalf of AMC.
All right, Ms. Kaminsky, this is defendant's motion, so I'll let you get started.
Great. And I assume, is the court reporter taking down all the, okay, great. We would like it taken down. I may have missed that in the beginning. So yes, this is AMC's motion for summary judgment. This is a pretty straightforward slip and fall case. The plaintiff came to an AMC location in Buckhead that is now permanently closed and was leaving her movie during the showtime and slipped and fell directly outside of kind of the threshold from the auditorium to the lobby. We are moving for summary judgment for two reasons. One, she hasn't put any evidence into the record of anything that caused her fall. And two, even if there is some sort of hazard that may have caused her fall, there is no evidence that AMC had superior knowledge. And that is, I'll address the argument separately, but first, plaintiff here simply says, because she fell, there must have been something on the floor, and that is not sufficient to meet her burden of proof. People fall all the time and it's unfortunate, but you do have to show that there is something that caused your fall. This isn't a case where there's a puddle of water or there's some defect in the floor that she tripped over. This is just simply a case where she happened to fall. And then as far as the superior,
Kaminsky, didn't she testify that there was a wet substance that she found, a wet or oily substance that she observed after she fell? Wasn't that part of her testimony?
So her testimony was that she thought that there was possibly a wet or oily substance or something. She couldn't unequivocally say what it was.
All right, go ahead.
So, and then addressing the superior knowledge issue, I mean, it's undisputed by both parties that AMC didn't have actual knowledge of any hazard. And then it's also undisputed by affidavit from the general manager who was on duty that night that the area was cleaned 30 minutes before the showtime and that someone was inspecting the area every 15 minutes or so and no hazard was found. Additionally, someone went to the area, the same manager went to the area immediately after the fall and didn't find any hazard. So to that end, I don't think that plaintiff has met her burden of proving that AMC had any constructive knowledge of this hazard that allegedly caused her to fall. And the other thing I kind of want to address is plaintiff in his response brief sort of touched on the issue of spoliation. There's not a spoliation motion before the court, but I'll talk about it anyway. There were video cameras in this particular AMC location, but it is undisputed that these video cameras would not have captured plaintiff's fall or the area where she fell. So to infer that this was a destruction of evidence is unfair because there's simply no evidence as it wouldn't have shown the fall itself. You can speculate all you want that you could see someone possibly walking to inspect it, but you would have no way to see if it was or if it wasn't. And I think in our reply brief, we cited a case directly on point that you essentially don't have to corroborate your witness's testimony. If he says it's happened, in the absence of other evidence, it has happened. And I think this whole thing is kind of being characterized as some big cover up, and that's just simply not the case. This was a very straightforward an unfortunate slip and fall, but there's simply no evidence to support plaintiff's claims at this point.
All right. Ms. Brogdon?
Thank you, Your Honor. Your Honor, basically, this is a case about credibility. It's the credibility of Ms. Craft versus the credibility of AMC. And we believe this case should get to the finder of fact in this case, and that's the jury. But before we get into the argument, I would like the court to recognize we filed our request to file original discovery back in October of 2021, October 1st. I do not believe that the original discovery, specifically the responses to our request for admissions, interrogatories, and request for production of documents, and the supplemental responses to the interrogatories, request for production of documents, and accompanying document production has been filed with the court. And I'd like the court to order that that be filed so that it is on the record, because I know the court is obliged to search the entire record before issuing a ruling on a motion for summary judgment under Georgia law or Georgia precedent. But
You have my permission to file the original discovery, so it's in.
we filed ours. We requested that they file the original discovery because it's important in this case, and I don't think they have.
So when we talk about original discovery, so the court doesn't hold on to the original discovery materials. If they get in the record, they get in the record electronically, and that's what I'll treat it as, unless somebody says unless somebody raises some objection or says this has been altered in some way. But the electronic record that's in the court file is going to be the record. So whatever needs to be filed, you can file it if the other side contends that somehow it's not the correct document or it's not authentic, then we can deal with it. But whatever you want to have in the record, make sure that it's in the record for me.
Thank you, Your Honor. So in getting to the first argument about knowledge, constructive knowledge, in this case, I believe Georgia case law states that you have to have a written instruction or written inspection policy or procedure. And if you don't have one, you need to show that it was adequately followed. AMC, we took the deposition of City of Kimsey, and she was the corporate representative of AMC. She was the voice of AMC, and through her, AMC admitted that they have no written inspection policy or procedure in this matter, and further, that they could not verify who inspected the area where Ms. Craft fell or who cleaned the area where Ms. Craft fell. And it goes directly into the constructive knowledge piece, because I believe it is Avery versus Cleveland Avenue Motel Inc. That's 239 Georgia App 644, and also Colvin v. Brentwood Manor, which is 251 Georgia App 477. And if AMC is trying to negate a claim of constructive or superior knowledge based off of an inspection procedure, then it must produce evidence that it has a reasonable inspection procedure, preferably documentary evidence, which it doesn't have, and that it was followed on the day in question. And so the testimony, the evidence before this court shows that AMC does not have such a procedure in writing, that AMC cannot verify who inspected the area or who maintained the area. And thus, plaintiff is not obliged or has no duty to prove how long the hazardous condition existed based off of Georgia precedent, because they have to have an inspection procedure, and it has to be shown that they followed it, and preferably Georgia courts will prefer that it is documentary. Now, the evidence in the case, and I believe, Your Honor, you've pointed out to this to Ms. Kaminsky about what caused Ms. Craft's fall, it's clear. She says that it was a watery or oily substance. And I would point the court to page 28, lines 5 through 10 of her deposition, where she's asked, how would you describe the substance that touched your hand? And she says, like I said, it was just like a wet water or oily substance, but I don't know what it was. Could you see it on your hand? She says, yes, I could see it on my hand. And so there, it's clear that she fell on something that she's identified, even though she doesn't know the content of the substance, right? Or the actual makeup of the substance. She said it's watery or oily, and she could see it on her hand. And further, it goes into the testimony of AMC, and that's why we want the original discovery to be filed. Because back in April 13th of 2018, AMC says that, look, there was nothing on the floor. We sent requests for admissions asking if they've identified a foreign substance after being alleged of the slip and fall. And AMC says, after reasonable inquiry, we don't have information or the information readily available to it. We can't admit or deny this request. And so then they're saying they don't know, even though this is 2 years after the incident where they're saying there was nothing on the floor. Then we get into the deposition. And then when we get into the deposition, AMC basically says, again, we don't know whether or not something was there, but it's our position that there was nothing there. And they give an affidavit that was signed on the date the motion for summary judgment was filed by an individual named Kerry Johnson. Now, that affidavit was sent almost 2.5 years after the incident. And the reason why we believe this is an issue of credibility is because Mr. Johnson, if they filed the original discovery, he gave a statement, a recorded statement on April 20th of 2018, 7 days after the incident. And when he was asked, when was the last time that area would have been inspected, his response was verbatim, we train our employees to clean these areas, the tile areas, every 30 minutes. So probably 30 minutes, it should have been cleaned before the showtime. And so the affidavit is more definitive, and I could play the recording. I don't know if it will play here, if the court would allow, but the statement that was given 7 days after the incident is clearly different than the affidavit that is being put before this court to really pervert the facts. And so in the deposition as well, when we look at whether or not, again, this is a credibility contest between Ms. Kraft and the AMC. Ms. Kraft is saying, hey, look, there was something on the floor. I saw it on my hand. AMC is saying through Kerry Johnson that there was the floor of that area was cleaned 30 minutes prior to showtime. AMC also admits through the deposition that they have a policy or procedure where when they are informed of a slip and fall, that they take a picture of the area where the alleged incident occurred. But that policy was not followed on the date in question. Further, during the deposition, 30 minutes into the 30B6, while we're deposing AMC, we were presented with documents that we were requesting when we had a couple of discovery disputes, but never alerted the court. We requested these documents a while ago. 30 minutes into the deposition, as you'll see from the transcript, they produce a document that's titled Slips, Trips, and Falls. And at the bottom of that document, I think it's the 4th section, it talks about what to do when there's a spill. And so throughout the deposition, Ms. Kimsey, or AMC through Ms. Kimsey, stated that they were informed of the slip and fall. They went to the area where the alleged slip and fall occurred. They had someone stand by the area where the alleged slip and fall occurred. They went over and mopped it, and then they put down a wet floor sign. And so that is the policy. If we go to the exhibit that was attached to the deposition, that was the policy for what to do when there is a spill. And so AMC's position is that, well, the floor was cleaned 30 minutes prior. There was nothing on the floor because even though we don't know who inspected it, it should have been inspected and it should have been cleaned. And when we were alerted of the alleged slip and fall, we didn't see anything, but we still perform the policy for what to do when there's a spill. And their only answer to that was, well, just because there was nothing there doesn't mean that it didn't need to be cleaned. And so this is a credibility contest, Your Honor, as it relates to the genuine material facts at issue in this case. And one of the main things is this case is clearly just based off of testimony. They didn't even take a picture of the area. They cleaned the area after. It's kind of one of the things that a jury needs to decide. I think we've met our elements legally, and their lack of an inspection procedure in writing and their lack of being able to verify that it was followed. I think Georgia law allows us to proceed on the merits. And further, I'm filing my motion for spoliation, motion for sanctions for spoliation. And I think counsel has missed, they've missed the argument, and even though it hasn't been filed. And so the argument is this, Your Honor, in the deposition, Ms. Kimsey, who was the voice of AMC, stated that there was a security camera from 4 to 5 feet from the area or the entrance to where Ms. Kraft was going. AMC's, one of the cruxes of AMC's defense is that that area was inspected 15 minutes before.
All right, Mr. Brogdon, I'm going to stop you there. You say you intend to file a motion for spoliation sanctions, or you have filed one?
I have not yet.
All right, but you intend to. I'm not going to decide this motion based on spoliation. So there's no need to argue that point. If you file your motion, then we'll get that issue joined fully and directly on that issue, and then we'll deal with what we need to deal with on the spoliation.
Yes, Your Honor. Thank you, Your Honor. Well, briefly, as I close, Your Honor, there was something on the floor, as Ms. Kraft has stated. They did not follow their own policy in taking a picture of that area as they were required to. They then followed a policy for cleaning up a spill, even though they claimed there was nothing there. We believe that the record before this court presents facts that show that there is a genuine issue of material fact that is being disputed, and we believe this case should go to a jury and proceed on its merits. Thank you, Your Honor.
All right. Ms. Kaminsky, you get the last word if you want it.
All right, I'll just address two quick things. First, I think it's a misstatement of Georgia law to say that you are required to have a written inspection policy. It just has to be reasonable. And here, the evidence in the record from this affidavit of Carrie Johnson says that it was followed on that day, and that should be sufficient. The other point I want to make, addressing the question about the RFAs and AMC saying they didn't have knowledge, those were prepared by counsel at the peak of the pandemic. Honestly, the employees were on furlough, and I could not verify the responses with them at that time. We're happy to supplement them if that makes everyone happier. And then the final thing that I wanted to address is about the difference between, or the alleged difference between the affidavit and the recorded statement. The recorded statement's not in the record. We're fine if it gets put into the record. It says what it says. I'm not going to dispute its authenticity, but if you listen to it in its entirety, you will see that it tracks what is said in the affidavit. They're the same person, and they give essentially the same testimony regarding AMC's inspection policies and whether or not they were followed on the date of this incident.
Do we know the employee who actually did the inspection?
No, we do not.
And we don't know the time because there was no method of recording the time when inspections were performed. This was more informal.
Correct. There's no inspection log that says, hey, this happened. But there's case law in Georgia that does not require you to have a written inspection log. That is above and beyond what is required.
Understood. All right. Anything else, Ms. Kaminsky?
I think that's it, unless you have questions for me.
All right. I don't have any other questions. I think this is a case more about the weight of the evidence rather than the absence of the evidence. As to whether there was a hazard, the weight may be on the defendant's side here as to whether there was a hazard, but there's testimony that there was, and the jury gets to decide that whether it weighs towards one side or the other. On the issue of whether an inspection was performed, the evidence is to me is equivocal, and the statements are equivocal. It's not a slam dunk. There's no way an inspection could not have been done. We believe an inspection was done. That was our policy to have the inspection done. The manager believes inspection was done, but we don't have what's definitive confirmation of that. And given that there was some equivocal statement out there, and given that there was a hazard warning placed out there after the incident, there at least raises a slight question as to whether hazard was there and as to whether an inspection was performed according to the policy. It may be a difficult hurdle for the plaintiff to overcome at trial, but it's within the jury's province. So the motion for summary judgment is denied. Mr. Brogdon, if you would prepare an order, run it by Ms. Kaminsky. Ms. Kaminsky, if you would approve as to form, or if you don't, you can, and y'all can't work out as to the proper form of the order, you can send it to me noting that objection, Mr. Brogdon, and we'll get it entered.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you both. Y'all may be excused.
Thank you, Your Honor.
All right. All right, let's go to Dewana Lane versus M Entertainment. So the posture we're in, we had an initial hearing regarding the amount of fees to be awarded. I ask that Mr. Freed supplement the record, which he has done. I invited Mr. Kasdorf to respond to that, which he also has done. I am prepared to rule on this, but I wanted to give the parties one final opportunity to address anything that they need, or that they feel they need to address to me. But I have read all the documentation and the responses, and also give Mr. Kasdorf, if he would like, an opportunity to question Mr. Freed about the fees. I don't believe that, based on what Mr. Kasdorf you have submitted in your papers, that you have any specific questions for Mr. Freed. I think you've laid out your objections and concerns very well, but if you want that opportunity, I will give that to you. So first, I'm going to ask Mr. Freed if there's anything supplemental or anything you wish to add other than what you've already submitted, which I have read.
No, Your Honor. I think the supplemental briefs and my affidavit speaks for themselves.
All right. And Mr. Kasdorf, is there anything you wish to add, or do you wish to question Mr. Freed about anything relating to the affidavits?
No, Your Honor. I think that the matter's reasonably presented on the papers, and I don't think I need to ask Mr. Freed any questions. I'm not gonna, as this court knows, we've not disputed Mr. Freed's rate or in general the quality of his legal services. We just think that a court's review of the hours spent on the motion for sanctions will conclude that that's an unreasonable amount of hours. And I'm not going to sort of insult Mr. Freed by questioning every bit of that time. I think the court just needs to make a determination as its own professional judgment about what a reasonable amount of hours to bill on that project was.
All right. So let me just, I want to address some of the issues that you have raised. First, about excessive hours on the sanctions motion. I got a very detailed and extensive notebook. I think perhaps even more than one notebook when we had the updated sanctions motion, detailing the history of this case, the testimony, the discovery issues, the prior case. We got the video. There was extensive work done on this case and on the sanctions motion because there were extensive issues. And I think all of that work was necessary and appropriate to advise the court of the extent of the conduct and all of the surrounding circumstances. So I agree, it was a lot of time, but also I note that there was a substantial record produced. There was a lot to show for the time spent in preparing the motion for sanctions and the updated motion for sanctions. So I do not believe the hours sought are excessive. The other issue that was raised was that the fees should begin to accrue at the time that I advised orally that 9/15/14 might be in play. And I will just say this. Before I award sanctions, I usually like to give some folks a warning and say, hey, we're going down a dangerous road here. Sanctions may be in play if you continue to push this without basis or for unnecessary and unreasonable delay. And the fact is that if after that hearing, there was a voluntary dismissal, and I recognize it would be with prejudice, but if plaintiff's attorneys had let the lawsuit go, the motion for sanctions and fees would have been denied. But that didn't happen. And what we got after that was, at best, a half-hearted effort to hold the claim. No substantive cognizable legal theory. Inadmissible evidence. And continued to force the defendants in this case to defend against the lawsuit. And the lawsuit, it wasn't minor. This wasn't a fender bender. This is a death case. This is something that had the potential to result in huge damages. So they had to defend it, and they had to defend it vigorously. And you know, you defend things, and then you point it out to the other side, and they say, okay, we give. And if they give, then you did your job, and you earned your fee from your clients, and everybody goes their separate ways. But they did their job, and the plaintiff's attorneys in this case were not dissuaded. And so the consequences are that they flow from when they knew they did not have a cognizable theory. I don't fault for saying, hey, there was a crossfire, and that's how he got killed at the beginning. But once you do your diligence, and once you do your discovery and decide you don't have that theory, and you can't come up with another cognizable legal theory of recovery, you got to give up. And that just didn't happen. So I'm going to award fees in the amount requested as modified by Mr. Freed's subsequent affidavit, in the amount requested of $219,038.77. That will be my order in judgment. I think, Mr. Freed, y'all submitted a proposed order before we dealt with the amount, which I have not entered. I'd like to enter one order that deals with both the reasons for awarding the sanction and dealing with the amount of the sanction. So I'm going to ask if you would to submit a revised proposed order that includes the amount and how that was calculated.
We will do that, Your Honor. Thank you. Maybe we have it full early next week.
That's absolutely fine. And again, run it by Mr. Kastorf so he can approve as to form. I suspect this may not be the last we hear of this issue. So, Mr. Kastorf, you can approve it as to form, and then you and your clients can your options from there. All right. Unless there are any further questions, I think we're concluded. You all may be excused.
Thank you, Your Honor.
Happy holidays.